Education, Labor, and Pensions will please come to order. We have a vote at 10:30. We might have another one after that, but what I think we can surely get through the opening statements, the Secretary's statement, and I think Senator Murray and I can get through our questions. What I will do is I'll try to go vote early and then come back, and in the meantime we'll continue the hearing so all senators will have a chance to use their 5 minutes and ask their questions. This morning we have a hearing on oversight of the Every Student Succeeds Act. Senator Murray and I will each have an opening statement, and then we'll introduce our witness, the United States Secretary of Education, John King. Secretary King, welcome. We're glad that you're here. This is our fourth oversight hearing on the Every Student Succeeds Act. Secretary King, you and I have had some debate on the meaning of words in the law, some discussion about it. It reminded me of Lewis Carroll's book, Through the Looking Glass, when Humpty Dumpty said, "When I use a word, it means just what I choose it to mean, neither more nor less." Like Humpty Dumpty, we choose our words carefully, and we did when we wrote the law fixing No Child Left Behind. We held 24 hearings between 2007 and 2014. 2015, we had 3 hearings. There were 58 amendments, many other amendments. The words we used were debated, carefully and deliberately chosen. We meant for the words to mean what they say, nothing more, nothing less. That, of course, is our job. The Constitution settled that a long time ago. An elected Congress chooses the words that make the laws. It's the executive's job to implement the law in a way that's consistent with the meaning of those words. Let me give you an example of doing that properly. When I had your job 25 years ago in 1992, Congress did something I very much disagreed with. It passed legislation adopting a pilot direct loan program. I had argued that the Department of Education had no business being a bank for millions of students. There were far too many problems, risks, and costs, but Congress disagreed, passed the legislation, the President signed it, and adopted a pilot direct loan program. After the President signed the bill, I had about as much time left in my term as you do in yours this year, and it was my job to start implementing the law Congress passed with which I disagreed. So I did it. And I faithfully followed the words, and I asked all the universities whether they'd like to be a part of the pilot program, and over time, eventually, about 25% did. I implemented the law the way Congress wrote it. Now, let me give you an example of how I think the Secretary of Education should not respond when implementing a law Congress written. I'm not going to dwell on it because you and I have discussed it, and we did again this week, but it's the proposed supplement, not supplant regulation. That was rejected by a negotiating rulemaking committee. It's a very simple provision that simply says federal Title I dollars that go to local school districts are not meant to replace state and local dollars for schools. If you give Title I money to a school district has to show the school is getting the same amount of state and local dollars it would receive without Title I money. One witness testified at the last hearing the law was so plain that there didn't even need to be a regulation, but you've come up with a proposal that forces school districts to show they essentially equalized spending of their state and local dollars among Title I and non-Title I schools, although the new law in Section 1605 explicitly prohibits exactly that. According to the Congressional Research Service, the proposed regulation, quote, appears to go beyond what would be required under a plain language reading of the statute. The proposal is so far out of bounds, these are my words, that I'm assuming any regulation, if there even needs to be one, will bear no resemblance to the proposal you've drafted. But let's talk today about the accountability rule that the department proposed on May 31st. This goes to the heart of the law to fix No Child Left Behind. In our studies, we heard more about testing than any other subject. I even at first proposed we eliminate the federally mandated test, but the more we got into it, the more we understood that it wasn't the federally required 17 tests that were the problem. It was having the U.S. Department of Education make all the decisions about what to do about the results of the test, which is what we call the accountability system. The federal government decided that math and reading test results would determine whether schools and teachers were succeeding or failing. And I believe that the reason we got 85 votes in the Senate, because so many were tired, and these were teachers, governors, chief state school officers of the United States Department of Education telling school boards and classroom teachers in states so much about what to do with the children in their schools. So I want to make sure that any regulation that your department proposes about accountability is consistent with the words we chose and the intent of the bill the President signed. You're receiving comments until August 1. You'll consider those comments. I look forward to working with you and continuing the discussions we had this week to ensure that the regulations comport with the law. Today I'll focus on two main concerns. I'll mention them just briefly. One is, does the proposed accountability rule actually get the federal government back in the business of setting state academic standards? Senator Roberts asked you about this during your confirmation hearing. Under No Child Left Behind, the department in effect mandated that states adopt Common Core standards. 38 out of 42 had to in order to receive waivers from No Child Left Behind. This new law repealed that effective mandate in at least 5 different specific prohibitions. There's nothing unequivocal about it. We also changed the law from requiring a state to demonstrate that they've adopted challenging standards to saying that all a state had to do was to assure the Secretary that it has adopted those standards. We chose our words carefully, but your proposal in this regulation says a state must, quote, provide evidence at such time and in such manner specified by the Secretary that it's adopted these standards. Wouldn't this give you the power to reject the standards by rejecting the evidence? The second area that I want to mention is, does the proposed accountability rule get the federal government back in the business of deciding which schools are succeeding or failing? It appears to reinstitute the failed No Child Left Behind formula, requiring that math and reading tests be the primary measure for deciding whether schools are succeeding or failing. You've invented out of whole cloth a so-called summative rating system that's nowhere in the law, that would essentially require all states to come up with an A through F system for all their schools, based primarily on test scores on federally mandated tests in math and reading. The whole point of the law was to return to the states whether to do that or not. I know that New York and City and Florida did that, but other states might not want to do it that way. Senator Murray often talks about the law's guardrails, and we agree there should be some guardrails in this law on what states must and may not do. But again, we chose our words carefully. They were carefully and vigorously negotiated, and any regulation must stay within those words. In fact, the law also includes some very specific guardrails on the Secretary, specific prohibitions. For the last 15 years, the federal government has gradually become, in effect, a national school board. Congress decided last year to reverse that trend. The President signed the bill. That should put an end to it. So on August 1st, we really come to the end of an era. I call it the end of the Mother May I era, an era when governors and chief state school officers had to come to Washington to get permission to do a number of things about their schools. Those conditional waivers are gone. The following mandates are gone from No Child Left Behind: the standards mandate, the adequate yearly progress mandate, the test-based accountability, the school turnaround models, the highly qualified teacher requirements, the teacher evaluation mandates. Those responsibilities have now been restored to states and local school boards and classroom teachers. Our hope is that this new flexibility will unleash a new era of innovation and excellence in student achievement, one that recognizes that the path to higher standards, better teaching, and real accountability is classroom by classroom, community by community, and state by state, and not through Washington, D.C. Senator Murray.